46 appellate opinions were handed down in Texas courts this week. Beneath that sheer volume of paper lies a series of critical tactical shifts. Welcome to the Texas Family Law Appellate Digest for the week of March 27th. I'm Tom Daly, board-certified family law litigation attorney. Our objective today is straightforward. We are synthesizing those 46 disparate opinions to extract the exact procedural signals you need to survive at trial and on appeal. The central tension across this week's docket is how appellate courts are interpreting and enforcing procedural rules. We are seeing a distinct split. On one hand, the highest courts are pushing back against opposing counsel weaponizing deadlines. On the other, intermediate courts are summarily dismissing cases over basic compliance failures by practitioners. Relying on assumed procedural protections is a trap. Surviving an appeal requires hypervigilance and strategic record building long before the final judgment is signed. We begin with expert witness strategy and the rigid boundaries of expert designation. Litigators dread the scenario where a designated expert suddenly drops out or becomes unavailable on the eve of a critical trial. That is precisely what happened in Diamond Hydraulics. A designated expert suddenly relocated out of state and flatly refused to testify. The trial court blocked calling a substitute expert, citing strict Rule 193.6 deadlines. Rigidly enforcing this forced a trial by ambush, stripping the party of the ability to present their case fairly. The Supreme Court reversed this exclusionary order, bypassing the strict deadline wall by introducing specific conditions. They clarified that the good cause standard for late substitutions is not an impossible threshold to meet. To utilize this ruling, you must meticulously and immediately document the genuine, unforeseeable unavailability of your original expert. Second, you must explicitly offer a substitute expert who holds identical opinions to the original, ensuring the opposing side faces no new surprises. Procedural rules exist to ensure fairness. The Supreme Court has signaled they will intervene when those rules are weaponized to strip a party of essential proof during a genuine crisis. Turning to marital assets, we look at how vulnerable premarital agreements can be in practice. In the Dallas case, in the interest of AB, the couple's marriage was governed by a strict no community property premarital agreement. Despite that ironclad contract, the appellate court awarded a highly valuable diamond ring entirely to the wife as her separate property. The legal mechanism allowing this is an interspousal gift. Looking past the agreement, the court examined conduct. Because the wife wore the ring for years and the husband paid for cleaning, this proved donative intent. We see the opposite outcome in the El Paso case of Flack v. Mendoza, which centered on a $30,000 offset in home sale proceeds. The wife appealed the divorce decree because it awarded the husband the first $30,000 of the sale. Her appeal was doomed by a fatal error, failing to request findings of fact and conclusions of law. Lacking findings, the court was obligated to imply findings against her, specifically waste and dissipation. Property appeals are won or lost at trial. If you fail to build a valuation record or demand written findings, appellate courts will unconditionally defer to the trial judge's just and right division.
Next, we review the Child Protective Services dockets and how the courts are currently evaluating the threshold for endangerment. In CRF v. DFPS, a mother led police on a high-speed chase with 3 of her children inside the vehicle. The Third Court of Appeals affirmed the termination of her parental rights. They explicitly noted that a physical crash is not required to meet the legal definition of endangerment. The court combined this extreme high-risk conduct with the parents' baseline unstable living conditions to finalize the termination. In Amarillo, the court applied the best interest standard to an older child, a 15-year-old, in the interest of JEH. The affirmation of termination relied heavily on 2 facts. The teenager was thriving in a current stable placement and clearly expressed a desire to remain there. Across both rulings, the appellate focus zeroes in on a parent's failure to complete basic service plans or secure safe, consistent housing. When applying the Hawley best interest framework, appellate courts are increasingly weighting the stability metric as the ultimate tiebreaker, prioritizing it over inherent parental rights. Finally, we arrive at the procedural gatekeeping that is quietly terminating cases before oral arguments ever begin. In Poff v. Poff, an appeal concerning a protective order was bluntly dismissed simply because the appellant failed to file a brief. We also saw an alarming trend of mandamus petitions, including In re Ross and In re ARM, being flatly denied this week. The mechanical cause of these denials was identical, failing to strictly comply with TRAP 52 formatting. Courts are rejecting petitions over missing certifications or unsworn appendices, regardless of the underlying crisis. Compare that absolute strictness for licensed attorneys with the 14th Court's ruling in Desta v. Wasihun. In that case, a pro se spouse sent a simple, informal email to the court regarding their pending divorce. The appellate court reversed a default divorce judgment against them, ruling that the informal email constituted a legal appearance, which legally entitled the pro se spouse to formal notice of the hearing. Procedural compliance is a one-way street. Strict rules will be leveraged to deny an attorney's defective filings, but you cannot rely on those same rules to insulate your case from pro se informalities. We can distill the intelligence from the March 27th docket into 3 operational pillars. First, expert strategy. If your expert is unavailable, you must immediately document that fact on the record and offer a substitute with identical opinions to neutralize claims of ambush. Second, record preservation. You must aggressively demand findings of fact and conclusions of law to prevent an appellate court from implying damaging behavior like dissipation against your client. Third, procedural compliance. Your execution of TRAP 52 certifications must be flawless. Grace is extended to the pro se litigant, never to the practitioner. An appellate victory is rarely the result of superior legal philosophy. It is the direct result of extreme procedural vigilance on the trial room floor. For the unedited analysis of all 46 cases from this week's digest, you can access the full intelligence library online. Maintaining an edge in Texas family law requires continuous, rigorous study of the shifting appellate landscape. We will see you next week.